Listen to the voices of the advocates.
Stephen Thompson, King's Counsel, took silk in 2005 and has a commercial practice at the London Bar, which focuses on civil fraud actions. He also has an active practice in the Caribbean and is regularly instructed on international arbitrations. In fact, he is one of the very few English barristers who has conducted a full trial in the Court of First Instance in Dubai. But to us, most interestingly, Stephen has a deep family connection with one of the giants of the Malaysian bar. Find out who that is on this episode of Advocates, the podcast. Stephen Thompson KC. First times we're saying those letters on the podcast. Welcome and thank you for spending your time with us.
Well, thank you very much for having me. It's a delight. I'm honoured to be invited.
Well, it's actually our honour, Stephen, and we normally start these conversations asking you a little bit about your background and your family. And the podcast, of course, it comes out of Malaysia. You've got a connection, so tell us a little bit about that connection and a bit about your childhood growing up.
Well, my mother's from Malaysia. She's Chinese Malaysian. She was born and brought up in Penang. She was born in the Second World War, and her family are all from Malaysia back generations. My father's English. My parents met at Cambridge when they were students. My mother then stayed here after she graduated, and they had me when they were both, seems quite young these days, and so she's been here ever since. But I've still got a lot of family in Malaysia. Both my grandparents, who are now both one's over 100 and one's just about to be 100. They're both in Penang, and some of my fondest childhood memories were going to Malaysia, going to Penang for holidays, which my parents packed me off to for longer than they could afford to take off work. So I used to go and spend 3, 4, 5, 6 weeks in Penang, every other summer for many years, in the days when you had to stop 3 or 4 times between London and Malaysia to get there. So, I have a great fondness and affection for Malaysia, and I haven't visited for a few years. When my children were born, I took them and they absolutely loved it as well. So I then started going again in middle age. But for the pandemic, we would have kept going. I haven't been for 2 or 3 years now, and I'm quite keen to get back.
I'm sure you are. And there were worse places than Penang.
Well, there are no better places for the food.
Yeah, absolutely. Tell us a little bit about growing up in the UK with a mixed family at that time. What was it like in school, and who were your influences?
So my mother came from quite an established family in Penang, but when my parents chose to live in the UK, they actually had to start again from scratch, really. So I was brought up in quite a sort of working class, run-of-the-mill area of southeast London. I was born in London and brought up in London. So it wasn't anything like my life would have been, I suppose, if I'd been brought up in Malaysia. But it was a very happy and comfortable lifestyle. My parents were both working from when I was a relatively young age, and they had a strong ethos of education. In fact, I must be one of the rare people who has 2 parents who went to university, 4 grandparents, and I think my mother was the 3rd generation herself. So they always had this emphasis on education. So they put a lot of store by that and encouraged me to work hard and to enjoy my studies, which obviously led me to do quite well and then go to university. So it was a lifestyle that wasn't, luxurious by any means, but was certainly comfortable and happy, punctuated with periodic visits to Malaysia.
And of course, you went to the family firm, Cambridge.
Well, that's right. I think I was the 4th generation on my mother's line to go to Cambridge. And I was very interested when I was at school in science and in maths. And so it was quite natural for me to gravitate towards natural sciences. And science is, Cambridge has got a better reputation for science probably than most universities in the UK, if not the world. And I was quite keen to go there. And it was incidental that my family had, because I'm not much or certainly wasn't much of a traditionalist when I was young. I quite like to think I was plough my own furrow. So I didn't sort of go up and shout about how I was from a long line of people that went to Cambridge, but I was. So I'm the fourth generation. My daughter's just applying this year to go to Cambridge, so she might be the fifth if she's lucky.
Gosh, yes, we'll cross our fingers. Razlan, you want to jump in?
Yes, it sounds like a pretty Asian background, to be honest, Stephen. The strong ethos in education and going off to university. Did you have any particular pressure to go up to Cambridge to keep up the family tradition?
No, I don't think it was any pressure, Aslan. I think you're absolutely right that there was that sort of Asian influence. But my father's family, who were very English, all from the north of England, also had a background in education. My grandfather was a professor. My great-grandfather, I think, on the other side was a teacher. So there was already this ethos of education on both sides. I don't think there was pressure. I mean, what it was, looking back, there was just always this unspoken expectation that you'd go to tertiary education. There was never any debate about, are you going to leave school at 16 and go and work, or are you going to university? It was just unspoken that was the rule. And, I think I didn't know at the time, but I think that was probably relatively unusual in the UK and probably in the West. And now it's, I think, much more common. And now the proportion of people that go to university in the UK has gone up massively from when I went to university, let alone from when my parents went to university. So I think, they were just a bit ahead of the curve.
Can I ask, natural sciences, why?
I really was most interested in science at school. I was lucky to have a very good maths teacher and a very good chemistry teacher and some okay physics teachers. And it was just something that always appealed to me. I mean, it sounds like sort of stereotypical boy subject, but I did really like it, and I did quite well in it, and I enjoyed doing it. And I was always encouraged to think about going to university to study a subject which I enjoyed. And I think that's good advice. I don't think you should go to university thinking, well, what subject would lead me to a good career? I think you should go thinking, what will I enjoy? Because then you'll do well in it. And certainly still in England, I don't think this is so much true in Europe or the US, but in England, it's still the case, I think, that if you do any subject, you do quite well in it, it opens doors for you across the board as an adult, as opposed to narrowing your options. So it's not the case that if you study science here, you will only ever get a job as a scientist, as I can prove. Yeah, so that was the thinking. I mean, actually, what happened during the course of my university career was that I realized I probably wasn't good enough or interested enough to become a top academic scientist. And I got interested first in geology, which was, and I think still is, an absolutely fascinating science, and then interested in history and philosophy of science, which was an option on the natural science tripos. And obviously history and philosophy of science isn't really science at all, it's history and philosophy. And so there's a bit more writing and a bit more debating and a bit more thinking about words on paper rather than things in laboratories. And that I think drew me off into thinking more about subjects that involved talking and writing rather than subjects that involved experiments.
We'll come shortly to how you made that turn to law, but I'm interested in your thoughts on perhaps one lesson you took from natural sciences that you have applied in your career at the bar. If there is one, of course.
It's very interesting. And can I answer it this way? Science obviously is an exercise in trying to discover the truth from evidence and testing the world and seeing what you can find and what conclusions you can draw. There are obviously parallels with law. Law also involves looking at evidence and trying to discover the truth. What I was really struck by when I started studying law is how the two disciplines approach that exercise in different ways, and how lawyers and scientists, even by the way they talk, think differently about that exercise. I mean, law does it in a very disciplined and structured way. Certainly in our systems, in the common law systems, you bring the evidence into court, and then there is a judge who is invited to look at bits of the evidence and draw his or her conclusions, whereas science doesn't have quite such strictures. Although, having read history and philosophy of science a bit, there are similarities, because science is obviously a human discipline, just like law is. And so there are processes that science follows that look a bit like law. There are hierarchies, there are people that follow other rules, there are people who have greater reputations and therefore who are more likely to be believed and listened to. And so there are interesting parallels. It is, as I say, when I first started studying law, I noticed it's a very, very different way of thinking, because lawyers, certainly common law lawyers, are always thinking in terms of rights and duties and responsibilities. And that is alien to science. Science doesn't think like that at all. And so there is a real different mindset in how you approach it. And I'm quite lucky, I think, to have studied both. Admittedly, my science degree didn't go much further than the age of 20, but to actually have the insight into how different disciplines approach their subject, I think is useful, or at least interesting.
So tell us about the journey from science to law. Why? I mean, let me tell our listeners, of course, your background, at least from Malaysia. The three giants at the bar: Kian Siu, Ken Chai, PG, who, your generation above. So against that backdrop, why did you pivot to the bar or to law?
Yeah, well, two generations above, and of course, to me, they were just relatives. So I wasn't really aware of their reputation. I certainly knew that my grandfather was a lawyer, but had no idea of his status or what he had done in his lifetime. For me, as I reached the end of my career at Cambridge, I realised that the subjects I was studying really didn't lend themselves to jobs that I'd be interested in. I mean, at the risk of offending geologists, the only job for junior geologists, certainly at that time, was sitting on a boat watching seismographs and trying to work out where the oil was. And that didn't strike me as very interesting. And history and philosophy of science, I did think about doing an MA and possibly a PhD, but I realised that actually academia wasn't really for me, and I much prefer, or I thought I would prefer, going into the real world and meeting more people. I spent a while contemplating it. I'll freely admit I actually did some traveling. I thought I'd quite like to spend more time in South America. I wanted to learn Spanish, which had piqued my interest when I was younger, and taught for a while in a school in Chile. And when I came back, I thought, well, now I'm 24 and 25 and I really haven't got a job. I need to do something. And law was quite a good way to sort of jumpstart a career, because it's a qualification which you can then move on. And to be honest, I didn't imagine staying in the law. I thought I would use it as a qualification and maybe go in-house or get a job in business or a company. But my ideas were all very ill-formed. I'm much like the sort of the young of today, where by 25 I had no idea what I wanted to do. So I was ahead of my time. I like to think in being clueless in my mid-20s. Yeah, and then I started doing law, and to my slight surprise, I actually started quite liking it. It took a while. I don't think it was much before I was 30 before I thought maybe I like this job. I was constantly thinking in my 20s maybe I should leave and do something else. But then I think by the time I got to about 40 or maybe 45, I thought, well, maybe I can do this job at least enough to make a living. So I stuck at it, and now I haven't got any choice.
We're unemployable doing anything else. Yeah,
Precisely.
So was there a point where there was a switch that flicked, which said to you, the bar rather than this in-house or solicitor's job?
To be honest, I was never very interested in being a solicitor. I thought if I am going to be a lawyer, I'd rather be a barrister. I think probably that switch was flicked when I was a teacher, because I was teaching in a secondary school in Chile, and I was teaching English, and I taught it in English. And I realized that I was quite good at presenting the topics at the blackboard to the children. But then what you have to do as a teacher, at least if you're a good teacher, is slightly let go control and let the children study and do their works in the book and walk around the classroom and encourage them and help them as they're working. That bit I was terrible at. I found it absolutely terrifying that they might be, misbehaving or not doing what I'd asked them to do. But the presenting I quite liked. And so actually I thought, well, being a barrister, I thought naively, I'd just stand up and explain stuff to a judge, and that's just like standing at a blackboard and explaining stuff to children. There are similarities, but it's not that similar. But sometimes it seems similar. Court of Appeal seems similar. But the solicitor's profession never really interested me, because I've got probably a very unfair image of them doing mainly paperwork. I mean, it is an unfair image, obviously, but I think it was the idea of presenting an advocacy that attracted me to the bar. I thought it's either that or go into some nebulous idea I had of business or work, which involved maybe making money or seeing people.
And it doesn't seem, from what you say, that there was any weight that you carried from, the two generations above you in there.
Well, I'm sure in the back of my head, I mean, obviously I was conscious, certainly by the time I was a student, of that history. And I'm sure it played some sort of subconscious influence on me. But I from a relatively young age, I thought, well, I really want to plough my own furrow. I really want to make my own way and not stand on the shoulders of other people. And maybe it was also because I was in England rather than in Malaysia. It wasn't as if the shadows of those ancestors of mine loomed over me. I mean, they're obviously part of family folklore, but that's family, and this was my studying and my job. So it wasn't something certainly that overshadowed my decisions, but I, as I say, probably in my subconscious somewhere, it was something I thought that I could do.
So let's now turn to Stephen Thompson KC, having finished the bar. You're looking for pupillage. How did you do that, and how did you end up where you did?
Well, I know you've interviewed many more eminent and senior people than me, and they'll tell you what the process was like at the time. I mean, there was no centralized process of pupillage. So I sent off, I think it was 68 letters applying for pupillage. And because I didn't have a first from Cambridge, I got a total of 9 interviews out of my 68 letters. But of my 9 interviews, I got 7 offers, which I was quite happy about. And so I did have a bit of a choice at that juncture. I was very much attracted to the type of sets where I've ended up and spent my career, the commercial chancery bar. I thought it was quite interesting. If you study science and then you apply for pupillage, everyone says to you, "Why don't you do intellectual property?" And I did some intellectual property mini pupillages, just a few days in a set of chambers, and it really didn't attract me. I found that the work, although it did have a sort of undercurrent of science running through it, was pretty mundane, or maybe just the luck of the draw of the places I went and the things I saw that week. Whereas the places I went to see commercial chancery work, I really found were interesting. There was a lot of getting injunctions, arguing big cases with lots of money and serious clients involved. And I thought these sound like cases where you can prepare, where you can get some run up to the court, but still it can be quite pressured, quite exciting. That's where I decided to go for my pupillage. And I had to do 2 6-month pupillages in those days. Rather than doing 12 months, you do 2 6 months. So I did two different sets, but both doing the same type of work. And the second one is where I still am.
Which is 24 old buildings.
24 old buildings, yes. Yeah,
okay. Any mentors during those young years? Were there any guys who stood out for you as teachers?
Yeah, well, I mean, obviously, when you're in the chambers, and chambers were generally smaller in those days, and ours was about 24 people. When you're in the chambers, you look first to the people in those chambers and the pupil supervisors you have. At the time, though, the commercial chancery bar had a handful of really well-known practitioners. I mean, at the time, Geoffrey Voss and Michael Briggs were certainly sort of ruling the roost. Certainly, my first pupillage, Michael Briggs was a relatively new silk in those chambers. And although I only saw him once or twice in court, he certainly wasn't going to deign to say hello to me or supervise me. He was a figure in the background that everyone knew about. And in my current set, our deputy head of chambers, who's only until recently was our head of chambers, Alan Steinfeld, was really another giant of the bar. And watching him at work remotely as a pupil to his junior was certainly inspirational. But you really, I think, have to operate a bit as a magpie in your pupillage and just see how all the different barristers conduct their practices and pick up all the bits that you think might be interesting and useful, and then meld that into your own personality to build a way of practice for yourself. And that's what I think I tried to do, though, again, only with hindsight.
Sure. I want to now turn to an area which, I mean, not many silks that we have interviewed have done, which is a slightly more permanent practice in the Caribbean. Tell us how that came about.
So my chambers, going back, I think, even to the 70s, had been one that had sought out and then developed some links with firms, offshore firms in the Caribbean, in the days when there was some work out there, but it was nothing like as prevalent as it is today. And so there were members of my chambers, some of the senior members, who were flying out there in the 70s and 80s and 90s to do work long before it became fashionable to do so. And I picked up on that. I didn't go out there in pupillage, but I knew it was going on. And when I was relatively junior, I got the opportunity to be seconded out to the BVI for a few months. And I went out there and I really enjoyed it. And I ended up being there I think it was nearly 9 months, and seeing a different way of life and getting to know a firm out there, Harney's, that at the time was pretty much the only significant firm doing offshore international work. And as I went through my early career, that offshore work grew and grew for our chambers and other chambers who jumped on the bandwagon too. And we as a chamber developed it, and we've always tried to nurture that. So I'm currently doing cases in Bermuda, in Cayman, and the BVI, the classic trio, if you like, in I can't call the Caribbean because Bermuda doesn't like being called the Caribbean, but in the Atlantic and Caribbean. And I've also been out to various other jurisdictions out there. So Turks and Caicos, I spent a long time doing a trial there. And there are lots of other jurisdictions where bits and pieces come up in that part of the world. And we've expanded that as a set of chambers into other offshore opportunities, Dubai, obviously, but also Hong Kong, Gibraltar, Channel Islands, and there are similarities and differences, and it's quite fun to be able to mix and match your skill sets to these places. There are some things which are directly transferable, and there are some things which you have to adapt and change and learn about to practice in these different places.
That's what I want to ask you about. Could you give us some examples of how you have to adapt with respect to, say, doing a trial in one of these Caribbean nations as opposed to a typical matter in the Chancery Bar in London?
It's very interesting, actually. So you find a very different tenor and atmosphere sometimes in the court. So I remember, for example, in one of the early hearings I did in the BVI, being pretty much told off by one of the judges there for being too sort of aggressive and jumping in too much. Now, I mean, in those days, in those sorts of hearings, there would be quite a lot of back and forth and interruptions in courts in London, certainly the lower level courts in London. And that did not happen in the BVI. They were much more respectful, and the tenor was much sort of lower key, and that was something you have to learn. And again, if you go to Dubai, I mean, although the judges in Dubai are drawn from all over the world, there are many from Malaysia, Singapore, Australia, as well as the UK. You do find there's a different tempo, there's a different attitude, because I think what we tend to underestimate as lawyers is how much legal cultures differ from place to place. I was on the Bar Council International Committee for many years. I was chair of it for 3 years recently, and it's really eye-opening to see how when you meet lawyers in different countries, although we share a lot in common, it's also interesting when you know them well enough to discuss the differences they have in approach, the way their relationships with judges in particular, but also fellow lawyers, clients differ. So the way Americans might treat their fellow lawyers is differently from how Germans might, for example. And the way you might treat a judge in Russia might be very different from the way you might treat it in Singapore. So it is interesting, I think.
Can I just follow on from that and ask, because I mean you are multi-jurisdictional, as you say, and Dubai, is one thing I want to come to just in a moment. But before you appear for the first time in a jurisdiction you have never appeared in, how do you gauge that tempo?
It's extremely difficult. It's a bit like appearing before a judge in your own jurisdiction that you haven't come across before. I mean, we all know that if you go back for a judge who you've seen 3, 4, 5, 10 times, then you know what he or she's going to be like. You know the way to pitch it and how much how many interventions you're going to have and how much of a free ride you're going to have, and how much they might trust you and allow you to do your job without without sort of raising an eyebrow or pressing you. And that isn't available to you if you have a new judge, and certainly isn't available if you go to another jurisdiction. I mean, we get emails through all the time saying, has anyone been before Judge X or Y? I'm sure you have the same, just to sort of try and gauge that. And if you don't know, if you really have no intel at all and your solicitor can't give you any insight, then I think you just have to go in as neutrally as possible. It's like being meeting somebody formal for the first time. I guess it must be like what the Queen feels like, or the late Queen felt like. You go and you meet someone, and you have to take a sort of neutral stance and see how it goes. I mean, it never hurts, obviously, to be deferential, to be respectful, and to listen more than you talk, and that's always a good starting point. Then you take it from there and see how it goes. Try not to roll your eyes when they annoy you.
Yeah, wear sunglasses.
Yes.
Dubai, tell us how that happened. I think you were one of the first people, or one of the few English barristers, in fact, to have conducted a trial in Dubai. How did that come about?
It was fortuitous. At Dubai work as the chambers. Michael Black, KC, I very nearly got his name wrong, was pioneering in that jurisdiction. He worked hard with the late Anthony Evans to set up the judge of the Dubai International Financial Centre, to set up the courts of the Dubai International Financial Centre, and worked with others to drafting up the rules, and became a sort of mainstay of that establishment. He wasn't in our chambers, but then joined us just shortly after the court really was up and running. And we were always to applications from people who had practices overseas. And so when he joined, he said to chambers, look, this is this opportunity. Who wants to come with me, take advantage, do some marketing, see what the place is like? And I put my hand up, and he was kind enough to take several of us out there and show us the ropes. And the practice grew from there. It's a jurisdiction that only really got off the ground from about 2009. And so it is a relatively new jurisdiction, and Michael involved me in some of his cases, and then I managed to get some of my own, just dealing with those sort of incipient questions for a new jurisdiction. What are the limits of the jurisdiction? Who can be served and brought before the court? How should the rules be interpreted? And it was fascinating, and still is fascinating, to deal with some of those questions. The interaction between that court and the other courts of Dubai and the UAE, as well as the arbitration processes. So it has been a really interesting process. I think I am certainly one of the few English barristers who's done a trial out there, because a lot of the work obviously is interlocutory. A lot of it is arbitration related. A lot of it is supportive or injunctions supporting other jurisdictions or other proceedings. And so it's relatively rare to have a trial. But I did enjoy having a trial. It was before a commercial court judge from London, a retired commercial court judge called Anthony Coleman, who's since passed away, who was a lovely tribunal. And he had retired, and he wasn't in his prime at the time we did the trial. So there are a few things you had to repeat so the bench could hear them. But it was instructive and interesting to do that. The courtroom in the DIFC is very plush, has fantastic leather armchairs for everyone to sit on, and the technology is second to none. So it's not like being in a drafty room in the Strand in the Royal Courts of Justice. But obviously in front of an English judge, the process was relatively similar. And this is what happens quite often in the DIFC. If you do have an English trained opponent and an English or a retired English judge, it just sort of becomes the default that you're doing it on the English way. It's different when you have a local or a Malaysian or an Australian judge, then you have to adapt slightly. But sometimes it does seem as if we transpose the whole thing. In fact, I've done one hearing where my opponent and the judge happened to be in London at the time. This was pre-pandemic, so we all did the whole thing in London and just turned a video camera on, beamed into an empty room in the DIFC, and pretended we were in Dubai.
So let me now come back to just ask you a little bit about your journey through the bar to becoming QC and obviously now KC. And the first thing I'd like to ask you about is the kind of work that you're known for. Yes, the commercial work, the sort of the company's work, the shareholders' work, but the one that struck me was civil fraud. What drew you to that?
So traditionally, sets like mine, commercial chancery sets, have done any sort of work which covers the field of chancery as a legal discipline, but the worlds of commerce in lay terms. And so that's covered everything from private family trusts, estates and wills work, through to property, through to commercial situations where there are some trust or equitable concepts, anything where one person ends up holding legal title to property on behalf of another. And obviously civil fraud falls into that category because of the concepts of constructive trust, and where a fraudster might be held by the court to hold assets on behalf of the true owner from whom he's stolen the assets. And so it's always been a string to our bow as a set of chambers. What happens, I think, inevitably in people's career is that they specialise a bit in some areas of what their chambers does. And although there's a lot of talk of how that is something that people steer and design and work on, sometimes it's just happenstance. For me, I was actually interested in civil fraud. I think it is a really fascinating area of work, partly I think from the initial attraction I had to this sort of work, which was the injunctions and the fast-paced work. And so it does still happen that you need to get an injunction very urgently in order to stop some monies going away or being spirited away, and you need to get it in secret. And there's something a little bit exciting about going to court against somebody without them knowing, and in an urgent environment. But you've got to do it carefully and properly, because you have extra duties, obviously, if you're going to court ex parte. So I've always found that area of work quite interesting as a start point. The stories are quite good as well. They're better stories at parties than talking about, banks and oil companies. So it's much more fun, I think, to do that area of work. There are much more opportunities you have, whether acting for a claimant or a defendant, actually. And over the years, you meet some interesting other lawyers who do that sort of work, increasingly in cross-border areas. I mean, this is an area of work which is par excellence international. I mean, there are very few domestic fraudsters these days. Generally speaking, if you've stolen some money, you better get out of the country. And so there are opportunities to work with lawyers in other countries, and multi-jurisdictional actions where there are proceedings in different places to try and recover assets or freeze assets. And I've always found that quite interesting.
Yeah, Stephen, you're absolutely right. The stories are much more interesting than I think for banks and all that. Gopal and I certainly know about this, but I'm interested. I'm interested in the fact that I went through your website, your background. You've done both sides, of course. You've done for the plaintiffs in recovering those alleged stolen monies, and you also acted for defendants who denied doing all this supposedly naughty things. Is there a difference in the approach that you take, or the preparation, or is just the same in the sense that you just switch it around for you?
I mean, I think it is very different, Razlan. I think it is different. I mean, there are, I think, three different types of people you might work for in a civil fraud case. One is the victim, the claimant. One is the naughty guy who has alleged to have stolen the assets. But the third category, which is maybe the most interesting, are other people who claim to be innocent, certainly weren't complicit in the fraud, but might have ended up being involved and caught up in it, and are then accused of having sufficient knowledge or sufficient involvement to be liable.
The knowing receipt chaps.
The knowing receipt chaps, but also the negligent chaps, the banks who didn't check their duties to their customers and so on. And those are the people who, genuinely feel morally outraged that they might be being sued at all, and think, well, it was not my fault, it's the bad guy who's taken the money. But of course, the bad guy's long gone. And they're an interesting category of people to work for. And I've certainly had some clients in that category who you feel really sorry for sometimes, because there are obviously philosophical discussions that you might have about the fairness of the extent to which those sorts of people should be required to cough up for monies that have been stolen by somebody else. But no, I think to answer your question, Razlan, it is very different. I mean, if you're acting for a claimant, you have to be extremely careful. I think that's the real difference. It's more fun sometimes acting for a defendant. In fact, probably the most fun is acting for the guy who really is a crook.
yeah.
Kind of have a bit of a leeway. As a general rule, I find if they don't ask you about about the merits of the case. They probably don't want to know for good reason. But the claimants, you have to be very careful indeed, because you can't put a foot wrong. You're always at risk of a guerrilla attack from the defendant for doing something wrong. And yet you really do have sometimes quite high hurdles to prove. I'm doing a fraud case in the BVI at the moment, and it's pretty obvious to everyone on our side that we've got the defendant on the ropes, but the judge really needs persuading on every point. Even though he's getting very skeptical about the defendants, he needs to actually get that over the line and get a judgment and get a recovery. You have to get every step right.
Can I ask you something following on from that? When you do act for the rogue, how do you distance yourself from him?
I don't think that's too difficult, to be honest, Gopal. I mean, they generally don't want to try and be your mate, and they won't tell you they're a fraudster, obviously.
No. Sorry. If I can just jump out, what I mean is before the tribunal, because there's always the optics. So how does one sort of put that optical illusion between yourself and the client?
I mean, obviously, it's critically important to remember all your professional duties at that moment. You have to be very careful not to mislead the court. I always find in every case I do, but particularly in these sorts of cases, it pays to be civil and polite to your opponent, to make sure that the atmosphere that the court sees is one of professionalism and not one of discourtesy. I think it is a huge risk to be so closely associated with your client that you end up taking up swords against your own opponent. And so I think it's quite important to keep that polite, civil, and even friendly discourse between your opponent, particularly in those sorts of cases. And the judge will pick that up, and the judge will recognize that you are doing your job. Obviously, the professional rules you can read in a book and follow them, but putting them into practice can be a skill. You obviously cannot present to the court things that are misleading, but there is obviously a heavy burden that lies on the claimant, and there's nothing wrong with requiring the claimant to jump through all the hoops that he needs to go through to prove the case. That's just part of the mechanics of justice, and that is something that you can always impress upon the judge. Whether it works or not, it's a totally different problem. But
and so, and this is coming from Kelvin and Dave over here, producers. How do you decide when you are acting for perhaps a guilty party, an alleged guilty party in the fraud? How do you decide how to pitch that case? At what level do you pitch it?
That's a very good question. I don't think I know the answer to that question. I think you just have to see what it is that is definitely going to be accepted by the court. What is the hard evidence, the emails and the texts and the documents which cannot really be questioned, however much your client might sometimes invite you to question them, and what areas are the points where the claimant is going to struggle. I mean, you do have clients over the years, certainly I've had clients over the years, who tell you, well, you need to tell the judge that is all complete set of forgeries, and everything there, all those emails have been made up by the other side in order to frame me. And although that's obviously a possibility and it happens all the time on telly, it's not likely to be accepted. And so it's your duty to the client to say, if that's what you want me to say, I will say that, but I am going to tell you that it will be hard for the judge to believe it. You're saying, in a way, I don't believe you, but you can't ever say that. But it's perfectly legitimate, and I think part of our job to tell a client who says that, look, I think I hear what you're saying and I understand what you're saying and I am listening to it. You do have to listen and you do have to understand the client's position, but I don't think the judge would accept that. I mean, if only because it does happen in films and on the telly, you do have to contemplate the possibility that someone's being framed. I mean, obviously it does happen. We've just had in England a very famous case involving the post office, which I don't know if you've seen, which involved the post office, the establishment, saying that their computers showed that there were numerous sub-postmasters who are often sort of small businesses in rural communities who've been stealing money across the board. And it was all a computer glitch. But all these, I mean, I think there were hundreds of sub-postmasters who were prosecuted and went to jail, and some committed suicide. And it was all because there was a glitch in the computer. So, you have to listen to a client who says, no, I didn't steal the money. It's an error on the computer. computer, they are setting me up. It isn't true. It absolutely happens. But you also have to tell them when it is true 99% of the time. I'm not sure the judge will believe you. We will explore this. We will push the point. We will press it in evidence and prior to the trial. But at the trial, you've got to recognise that judges will be pretty credulous, or at least tend to believe hard evidence and electronic evidence these days, and that's just the way it goes.
You took Silk in 2015. Am I right? Yeah.
As a QC.
Yes, you took Silk. You were QC at that time, KC now, forget. And moving from QC to KC over the last few days, what's that been like?
It's been seamless. Obviously, we woke up one morning and all the emails and the websites had been changed assiduously by the clerks and others. There are going to be obviously significant changes for this country and many others where the new king is the head of state, and there's endless discussion about that here for obvious reasons. Actually, the change for us as lawyers has been seamless. A lot of people have pointed out that we're now KCs and not QCs, from newspapers to friends, and it's going to take some getting used to. But then again, I don't suppose I'll ever be a QC again, so I better had get used to it.
And what was that like for you in 2015?
Taking Silk in the first place. It was amazing, actually. I mean, I applied twice. I didn't get it the first time. And it's a pretty rigorous and painful process to go through these days, has been since 2006. And but the thing about this job is you don't work in a team. You work in multiple teams, obviously, but you never work in one team. So you generally don't get feedback. You either get paid or you don't. And then you either get new instructions from the same people or you don't. And if you don't get new instructions, it might be because they thought you were hopeless or didn't like you, or you lost, or any combination of those things. Or it might be that they haven't got work for you in that field. But you never get, like in many jobs, a kind of 360 review from your boss saying, well, I suggest you do this and I suggest you do that, or from your staff saying you're a dreadful boss and I'm not coming into work today. So the only feedback you get really, and the only way of progressing in this job, is taking Silk. There's no other step. It's not like being a doctor where there are numerous different rungs on the ladder. In this job, you're either a junior barrister or you're a Silk. And if you want to go any further than that, you have to be a judge, which is a different job. So I think actually it is quite a pinnacle of your career. It's something that happens, about halfway, and it is a nice recognition. It certainly changes, I think, the way you do the job, because rightly or wrongly, it's still a pair of letters that has a lot of status behind it, I think, internationally as well as domestically. And I think you are treated slightly differently professionally by judges, by solicitors, by clients, particularly international clients. I mean, there are a lot of clients, say from Hong Kong or China, who say, no, I want a QC or I want a KC, they'll be saying now. And so there is a difference in the way that you're treated. I think being a junior barrister these days, in London at least, can be extremely hard work, because you end up bearing the burden of everything. The solicitors will look to you as being the last, where the buck stops, and you'll be doing the advocacy, and you'll be doing all the work through to 2 a.m, because that's when they give it to you. Whereas as a KC, as a QC, they tend to be a bit more respectful. They don't send you something at 5 o'clock saying, can you tell me the answer by 8 a.m? There's a little bit more sort of respect in the profession, and that makes a big difference to the way you do it, rightly or wrongly, as I say.
In terms of advocacy, right? You are now KC. Has there been a change that you notice yourself in which how you approach advocacy as a junior barrister now as a KC of 7-8 years standing?
I don't think there was no step change for me, put it that way. I think you get more experienced as you go on, and you learn more tricks of the trade and maybe develop your style more. I think what does change slightly, to answer your question, Razlan, is how the judges treat you. There was this sort of, I think probably still is, this rumor, this idea, this reputation that Silks get an easier time in court than juniors, and that judges will listen to you more and let you ramble on with rubbish before cutting in, which they might not do if you're a junior. I think there's an element of truth to that. I think actually what it is just a just a bit of sort of reverse ageism. I think the way judges are not all judges, but I think the way many judges are is they think, well, who's this whippersnapper in front of me who's younger than my daughter? I'm not going to take any notice of what she's saying. She must be talking rubbish because she's young and or a woman. I think that happens if you're young, and I think as you get older, and particularly maybe there's a step when you take silk, judges don't do that so much. The ones who know you might think, well, I trust him not to be wasting my time. I'll let him finish, even though I have no idea what he's talking about. But actually, others will just sort of. I mean, I think this is slightly changing, because I think the better judges, and certainly the majority of the judges these days in the higher courts in England, don't do this at all, and they're pretty respectful. I mean, we've got a campaign in the Bar Council about bullying, and it does still happen. But my personal view is that is a slightly older generation of judge on the whole, and it is bullying of a younger generation of lawyer. And I think just having a bit more grey hair kind of stops them doing that.
Okay, so let's now turn to a little bit of technique, which we tend to do in the last sort of 10, 15 minutes of our interviews. Cross-examination, and you do this civil fraud stuff. How do you prepare for it?
Well, I think the golden rule for any advocacy, and certainly for cross-examination, is preparation. I mean, what I do for any trial, witness trial, is read all the papers very carefully and assiduously. You have to know where everything is, and you have to know what everything says, however many sheets of paper there are. I mean, there might be a bundle or two which is just some pointless spreadsheets or messages that are well outside any relevant time period, which you can ignore. But everything else you have to be on top of, because part of the process of doing the trial well involves you being able to manage the paperwork. You don't want that to be a stumbling block. So if you are scrabbling around trying to look for something, it breaks the rhythm, it breaks what you're trying to do. So the first rule is, I think you have to know absolutely everything. In terms of cross-examination itself, the way I do it is I imagine, normally when I'm not at my desk, when I'm on my bicycle or going for a walk or in the shower, I imagine the sort of question I would want to ask, and then I imagine in my head being the most awkward but still intelligent opponent or witness to answer the question, and try to tie up that question in knots. So I sort of stress test the question. And I think that's quite a good way of doing it, because you then think, well, maybe I should ask the question a different way. I mean, I'm in, you won't be surprised to hear, a relatively argumentative family. And so, I have years and years of experience of having to, shout at people in a Malaysian way. And so, there is quite a skill, I think, to making sure that what you're saying can only be answered in a way that you want, that the answer addresses the point which you're getting at. Obviously, with cross-examination, there's a broader skill of kind of shepherding the witness down to the point, and so you start with the wider points and funnel them down. And the better you've prepared, and the better the evidence is that you've got, the easier that is to do. You can't just jump in and say, well, you're a fraudster, aren't you? But if you do have a strong case, a good evidence, and you've thought about the questions and where they're going to lead, I think that's perfectly possible to do. It is still, it's the part of the job which is still, I find, the hardest to do, but it's also the most rewarding to do when it works. When it doesn't, it's a disaster, obviously. But
And did you write down your questions, type them out?
well, I used to just write them out in notes, not in longhand, but sort of jot out points that would remind me in very rough form. I tend to do that still, but now in a printed document, because otherwise I can't read my writing, I find. But I certainly don't do it all verbatim, because it's impossible, I think, to predict even 5 questions in a sequence, let alone a whole afternoon of them. And I think you do have to be flexible. So I break it into topics, and then I'll certainly have the lead start question off. And then I have a good idea, once I remember what that lead question is, I have a good idea of what the topic is going to be and where I want to go, because I'll have thought about it in the preceding day or two. And then whatever the answer is, I'll have an idea of how I want to steer it. But I try to keep, even cross-examination, more of a conversation than just a sort of interrogation, because I think you have to, and obviously you do have times where the atmosphere can get very tense in cross-examination, but it helps with everyone apart from the utter crook. It helps to keep it as civil as possible for as long as possible. Oftentimes that means they don't actually see the killer question coming because they're more relaxed, or other times they're so tense that they're talking defensively from the start, and then the questions and answers are in your favor because they don't seem like they're telling the truth. But it's there are lots of different ways of dealing with people. You have to do it as many different ways, I think, as there are different personalities. So it's infinitely varied.
Right. So one more from the producers before I jump across to Razlan. Have you cross-examined another crook?
Oh yeah.
Yeah.
Okay. Several.
And was he exposed as such?
Oh, invariably. So I've cross-examined stupid crooks and clever crooks, and that's the really interesting difference, actually. I've cross-examined one person who I still won't name, who it was, I think, probably the most difficult cross-examination I've ever done. It was just before I took silk, actually. And he was extremely intelligent and very well prepared and tried to tie everything up in knots with clever answers. So he had probably anticipated what I was going to ask, or the topics I was going to ask about, because he would have read over everything in advance and had prepared his excuses. Not that he'd descended to put them on paper, obviously. And his answers obviously were designed to throw up the possibility that there was a whole bunch of questions that I hadn't considered. So I said, well, didn't you write this email? Doesn't that show the other? And he said, yes, but what you haven't considered is all those emails I wrote 18 months before between Bloggs and Smith, which you've got somewhere there in the 2000 bundles. And just to try and throw you off the scent. And that was extremely difficult. The stupid crooks are easier. Stupid crooks really don't have a credible explanation, and they just repeat that it's all made up, they're being framed, it's all rubbish. Yeah, hoping that the judge will believe the Hollywood story that it's all a setup, it's all a fit up.
I saw somewhere that you actually did a complete trial remotely. Of course, with COVID, it becomes a necessity, right? Was there a difference in doing it remotely as opposed to doing it physically?
Absolutely. I mean, now sitting here, 2.5 years after we first all started doing everything remotely, I've done everything from the Privy Council to a trial remotely, and we get used to it. I had to buy a lot of screens and microphones and cameras, but you do get used to it. I mean, I think if you'd asked any civil fraud lawyer, certainly if you'd asked me 3 years ago, could you do a fraud trial remotely? We would have all said no, it's not possible, because you need to have that atmosphere in the courtroom, the solemnity, the seriousness of the occasion, to impress upon all the witnesses that this is a process which they have to treat very seriously. Actually, I think all of our views have softened on that. It certainly is possible. It's nowhere near as good. I still don't think it's as good. You have difficulties, physical difficulties of passing bits of paper to other people, of whispering and discussing things in a courtroom. You also don't get to see the body language of all the people in court, and particularly not the judge. And on a screen like I'm looking at you have one person who's blown up and then some thumbnails at the edge, which is typical. And so you do get, I suppose, what one advantage is often the person you're cross-examining appears closer to you virtually on the screen than they would in a courtroom, because in a courtroom they'll be on the other side, and so that the angle of vision which they'll represent is quite small, whereas on a screen it can be quite big. But so you will see maybe more easily their facial expressions, but that advantage, I think, is offset, or more than offset, by the fact that you can't really see their body language, and you can't see so easily the judge's reaction, or indeed your opponent's reaction. And I think all those things which we underestimate as humans, as communicators, are really important. And so I do think there isn't. It isn't as good. I was going to say there's no substitute, but that's not true. It is possible. And I think, if and when we have the next pandemic, we'll just have to do it. And at least we know how. But I think as long as it's safe, we ought to try and do it in a real courtroom for all the advantages we know.
Okay, so let me ask you now, before I turn to rapid fire, because we're running out of time, about written advocacy. And clearly now that there's just so much emphasis on writing, everything you want to say prior to the hearing or after the trial. Do you write submissions yourself? Do your juniors give you a first cut?
It's 50-50. I mean, there are some cases where I don't have a junior, then obviously I do. There are other cases where there's a QC senior to me, KC senior to me, so I'll do more of the writing. And there are other cases where I have very, very good juniors who will do, if not the first draft, the only draft. And I have some cases where they're quite juniors, which obviously I will then do some rewriting. So I don't ignore it. I won't write every word these days, but I do quite a lot of it still. I think there is a skill to written advocacy. I think a lot of people still these days write quite badly. You can know all the law, you could even know all the facts, and still not be able to write it down in a way that's persuasive and readable. One thing that people, I think, are quite poor at doing is writing a 10 or 20 or 50-page document which can keep you awake till the end. And given, as we all know, that these pieces of written advocacy, these closing arguments and written submissions, are often the very first thing the judge reads, I think you do have to get their attention and keep their attention all the way through the document. And that, I think, is important to get right. I'm not a fan, however, of making the document contain everything. I don't want it to replace what I have to say, and so I am a big fan. I've always been a big fan of short submissions. We have a big pressure from the judiciary in this country to keep these things short, and that's because they don't want to wade through hundreds of pages of documents. But from our perspective, the advocate's perspective, it's also in our interest to keep it short. I think there is a fear in the profession that if you don't say everything, you might lose the case or you might forget it. I think you need to suppress that fear as an advocate when you're doing written advocacy, and make sure that your written document is just a series of signposts and tweaks the judge's interest enough to be able to ask more. I mean, let's face it, we're writing these things for an audience of people who have the same training and background as we do in our legal cultures. The judges have done our job before, so they're not stupid. They will understand that. And I think sometimes more is less. And you can say, well, there's this case and there's that case that I think you should look at, and there's this fact and there's that fact which is relevant, and therefore the conclusion is the other. But you don't have to spell out in laborious paragraph after paragraph every step of that legal reasoning like you might do in a textbook. And I think that's always the risk with advocacy: writing too much and trying to include it and then boring the judge, or making it so long they don't read it at all.
Okay, so here's the vexed question that I think we all struggle with. When you've written submissions, do you think about what you want to say in the oral argument?
Yes, I think I do. I think it's important to lay the groundwork and the structure of what you're going to say, because I think it works best when you stand up in court and say, well, I'm assuming, my lord, my ladies, you read my scares argument, and I'm not going to read it out to you. But what I want to pick up on, unless you tell me otherwise, are the main themes in it, and I'll follow those themes in my oral submission. So you follow the same structure. Now, sometimes they'll say, well, hold on a minute, I don't want to hear anything at all about points 1, 2, and 4. I only want to hear you on points 3 and 5. So can we deal with that? Fine, we'll deal with that. And so you can sometimes guide them, but it's also useful to have a framework for the judge to use as well. And there's a real adversarial benefit to that, because if you do it well, then the structure is going to be the one you've chosen, not the one your opponent chooses. And then if you're already on the right battlefield, which is a good starting place to be.
Excellent. Okay, so we're going to hit the rapid fire round now. We're just over 1 hour.
Sorry, I've been talking too much.
Oh, no. I mean, it's great. It's been brilliant. But I want to ask you before we do that, I'm sorry, I have to ask you about your grandfather, Ken Chai. I had the privilege of working with him. I don't think Razlan has. Tell us a little bit about him and what you know about him and what he taught you in those 6-week holidays in Penang.
Well, of course, he was first and foremost, he was my grandfather and not a lawyer. And I always remember going to his old house. It was great fun in his house. We ran around as children, and it was just to be in the tropics, in a tropical garden in Penang was amazing. And I remember when I was very young, he worked pretty hard and he was always in the office. And I remember going to his office sometimes to meet him in the middle of the day, and he wouldn't really know what to do with a small child in his office. And I remember the big fans on the ceiling and all the typewriters and the dark wood everywhere in the office. And then I remember at one time he said, "What do you want to do?" And I said, "Well, I want to play. I want to play with some Lego." So he went out to a toy shop which was down in downtown Georgetown, and went into a shop and said, which Lego do you want? And I just pointed as a 6-year-old to by far the biggest Lego set I could see on the shelf. And so having no expectation that he would buy that, because certainly my parents wouldn't have done. They'd have said, "Don't be silly, you could have this small one." And he just bought this thing for me, and I was completely bowled over. And for the rest of my childhood, thought he was the most wonderful man for buying me this enormous, well, what seemed at the time enormous Lego set. But I mean, I had no, because as a child I didn't really have any career aspirations to be a lawyer. I didn't sort of discuss that with him. By the time I qualified as a lawyer, he was, I think, in his 70s. And so he was certainly winding down his career. I did see him in court only once. And it wasn't a very long hearing. It was an appeal hearing, I think, in Georgetown. And then, and it was a relatively mundane thing, I think, but he was doing, as he often did, I now know, all these sort of pro bono things for people. And we ended up in a restaurant, and another great memory I have of my grandfather, which is a memory I have on many occasions, is him just generally bossing waiters around and telling them what he wanted, and then making them put on certain types of music or make some other dishes. And so, but he was with the client, and he obviously liked, as you, I'm sure you know, Gopal, he just liked being in the company of people, and there was a bit of holding forth, but there was an awful lot of just the interpersonal engagement with other human beings, and I think when it's all said and done, that's actually what he most enjoyed about the job he did. And he obviously was never a great academician, and but he had a strong sense of justice and what was right and wrong. A strong sense, still to this day at 102, has this sort of burning sense of justice about what should be done on the political and legal arena. And I think that's born out of his love of just of being with people and seeing that people have the right thing done by them.
Amazing description of him. Let's turn now to rapid fire. What do you enjoy most? The intellectual exercise or the interpersonal skills?
I enjoy them both. I enjoy the mix, but I think if you had to answer, and given this is quick fire, I'll say interpersonal.
Okay. The opponent you respect the most?
That's difficult. I've had a lot of. I try really hard to get on very well with all my opponents and not cross swords with them, and so I've had a string of opponents who I respect. The one that really stands out for me, I think, is Nigel Tozzey, KC, who led me and who I was then against in a few years ago. And I thought he was such a refreshing modern barrister, an intelligent and pleasant man who does his job fantastically well. And although he's not a person who's sort of known as being one of the great stars of the bar, I do think he's really the epitome of what a barrister should be. So I'll name Nigel.
Who have you learned from the most?
Well, again, like I was saying before, I think you end up being a bit of a magpie in this job. But if I probably tried to add it up over the years, it would be either Alan Steinfeld in my chambers, who's head chambers for 20 something years until this year, or one of my pupil supervisors, Stephen Mobley Smith, who I've done a lot of work with and have learned a lot from over the years, who from being my pupil supervisor to I was doing a case with him even last year. So it's been a whole career's worth of working with him and learning from him.
The judge who challenged you the most?
I had a hearing when I was in the BVI. I was a very young man, and I went to go to do a company winding up petition, and I had to, and it should have been a 5-minute hearing, but the judge, who was the local judge, didn't take kindly to English barristers, certainly not young English barristers, and he tortured me for 2 hours in the morning about the most basic principles of company law, the chapter 1 of your book, which are philosophical questions about how company law comes across, before deciding it was lunchtime and he'd had enough of torture and giving me my order. That was, I think, the most difficult experience I've ever had. I had not anticipated it being more than 5 minutes, and it was 2 hours. That's the biggest challenge I've ever had.
Okay. So next question. Outside the law, what does Stephen Thompson KC do to enjoy himself?
Oh, well, I'm generally quite lazy. Outside the law, there's not a lot of that time. But before lockdown and before I put on some extra pounds, I used to like doing a lot of cycling. I'm trying to get back into cycling. It's a very good middle-aged activity, and I like going out walking with the family and the dog, and just going out and getting out into the fresh air. I really like travel. I like traveling around the place. I really enjoyed the holiday I had this year, driving down to Italy and back and seeing new places. I can't pretend to you that I'm some talented amateur musician or singer or sportsman, because I'm not. But I enjoy my spare time in low key activities.
Right. Last question. Tell us about a day in the life of Stephen Thompson KC.
Well, goodness. I mean, there's no typical day. I think that's the first thing to say. I mean, one of the nice things about this job, I think, is that I'm not in court every day. And the benefit of that is that you have time to think and prepare. So I'll give you a typical week instead, a typical politician's answer. I'm not going to answer your question. Next week, for example, or even the week after, I'll be in court a day or two. I think next week I've got 2 days in the BVI Court of Appeal, and then a week or two after that I've got 2 days in the DIFC Court of Appeal, and so there'll be a lot of preparation for that. But in the meantime, I'll be doing calls with clients, with solicitors, at least 1 or 2 a day. They often pop up and people ask you at short notice, can you deal with this, or can you see what your view is about this letter? The advantages of modern technology, or the disadvantages maybe, is that you get asked to do things at quite short notice. I have, I think, probably half a dozen cases at the moment, big cases, which are all rumbling along, and which on any given week I may have to do anything between half an hour and 2 days work. So most of what I do will be that. So today, I'll give you an example. Today after this, I've got a call at 11:30 on a case that's coming up for an arbitration in October. I've got to finish some work on a skeleton argument for my Bermuda case, and I'm going to go into chambers and do something a bit like this. I think some filming for a pupillage video that we're doing. I'm heavily involved in pupillage in chambers, and I'll be writing something for their pupillage brochure. So a bit of everything.
Excellent. Well, we'll send you this video. You can put that on your pupillage, invitation as well.
Okay, yeah. Not sure that'll attract them.
I think it will. Stephen Thompson KC, thank you so very much for spending this time with us. This hour and 14 minutes has just flown by. Thank you.
Thank you for listening to Advocates the podcast. I hope you've enjoyed the program. Please follow us on all our social media channels. Leave a review or share this episode, and don't forget to tag us. We love to hear from you. Thanks.
Listen to the voices of the advocate.